Hello, everybody. Today, Monday, June 25th of 2018, Brendan Dassey was denied his writ of certiorari with the Supreme Court of the United States. Now, I've been talking a lot about this, but this video is meant for people out there that really have no awareness of the Brendan Dassey situation. I'll tell you what, in the last 2.5 years that I've been talking about Brendan Dassey, it's really kind of amazing how many people that I've dealt with that didn't even watch Making a Murderer. They kind of knew about Steven Avery and Brendan Dassey because obviously it was all over the news for a while and stuff, so they heard about it. They were kind of aware of it. But when I would explain the whole Brendan Dassey thing, they would find it, I could tell they could find it difficult to believe. They found it difficult to believe that anybody would want to do that to a 16-year-old kid with, learning abilities or with mental limitations. So I could tell they were having trouble. They have trouble with that and understanding it. So eventually, one of these people who I'm speaking of, I'm thinking of one person in particular, eventually caught the Dateline Return to Manitowoc. We all may remember it was one of the biggest Datelines that they did about the Steven Avery case. And it had, it had Griesbach in it, it had Fassbender in it and stuff. When this person that I know, that I'm talking about, watched it, this person let me just say, this person is a very staunch supporter, law enforcement and the state and all that. And he's, very staunch to the point of he supports the police even when they don't do things the correct way. He's that much of a supporter of law enforcement and, the state, basically. But when he watched the Return to Manitowoc Dateline episode and saw what was going on with Brendan Dassey and saw the parts of the confession in that show, he immediately called me up when that show was over. He immediately called me up because he knew I'd been talking to him about Brendan Dassey for almost 2 years, a little over 2 years. And he called me up and he goes, "Okay, you're right. They coerced that boy." And I was just like, "Oh, well, I'm glad we got you on board, buddy, ha ha ha," and everything. And then I said, "Well, what was it about it, that really got you? What was the big thing for you?" And like a lot of people say, he said, "I imagined if one of my sons was sitting there in that chair." And when people start to think about it that way, they start to think about how easy it is to coerce a juvenile, a youngster, especially with all the intimidation that's going on with a police interrogation at a police station. The implied implications are very significant and therefore daunting on their own. And then you add in that you suddenly have two authority figures browbeating a young 16-year-old kid with mental limitations, feeding him facts, basically telling him everything they want to hear so that he can spit it back out at them, later. So that you can't corroborate anything that he said because they basically gave him all of their evidence. They told him everything they wanted. And so there was no way for him to say anything that could be corroborated other than the only things that they can point to. And this is what makes the state of Wisconsin's argument so freaking weak. It's weak, people. I'm not kidding you. I am really not. Their argument is weak as hell. Okay? There's, number one, for anybody that doesn't know, there is not a single trace anywhere of Brendan Dassey in the supposed kind of two areas that this crime was supposed to have taken place, or even in the vehicle of the victim. So that's 3 different places. Not a hint of Brendan Dassey. No DNA, no hair, no anything, nothing to suggest that Brendan Dassey was around or a part of any of this. So that's the first big, issue, right? Then you have the confession, folks. And when you watch it, and trust me, I'm going to be putting together a video. Me and my friends, we're going to be putting together a video where we take all of the most crucial bits of that interrogation, and we're going to put them together in a way so that anybody can just, sit down for 5 or 10 minutes and just see all of the tactics in a very short span of time that were used against the kid. You see how Brendan Dassey reacts and responds to all this stuff. The promises the made, just so many things. We'll get to that so that you guys can actually see it. But for now, I mean, the fact that he was fed all of the facts, so that none of them came from him. But here's the trick: the only facts that he did suggest without them telling him to say, because he was guessing, and obviously with the kind of questions they were asking about what was supposedly happening, he eventually guessed that they were getting at a kind of rape and murder scene or whatever. So the few things that he did guess was he said that they stabbed her. He said that they cut her hair. He said that they raped her. Okay, these three things is what the state says. Because Brendan Dassey offered these three things, it means that his confession is valid. Okay. As I was saying before about how the interrogators fed Brendan Dassey every single, critical fact that they needed to feed him, so that there was no way for him to say those things on his own, because they had to, every single thing they had to tell, every single fact that he spits back at them was given to him by them before he says it. Every single one, except for these three that cannot be corroborated. They cannot corroborate that Teresa was stabbed. They cannot corroborate that Teresa was raped. And they cannot corroborate that her hair was cut, because they didn't even find a single strand of her hair anywhere. They didn't find a single drop of her blood in the trailer or in the garage where this crime supposedly took place. They didn't find any trace of her. They had zero trace of her. Okay, that was in this crime, just so people know, it took place on October 31st of 2005. Okay, let's skip forward now to March of 2006. March 1st. Okay. The investigators have a weak case against Brendan Dassey's uncle. They have a weak case. They know they do. They know that there's holes in it that you could drive a Mack truck through. Okay? They are worried that their case isn't strong enough. And what they're doing, say, like on February, like at the end of February, okay, basically, they are going and they're, Brendan Dassey's uncle Stephen had a girlfriend. Her name was Jody. She was in lockup because she had a little bit of a drinking problem. So she was in jail. And these two investigators, Mr. Mark Wiegert and Tom Fassbender, were going down to the jail and basically going in there and just giving her the third degree, trying to get her to say things about Stephen Avery. Basically asking her really personal questions, getting into really personal stuff. I mean, kind of creepy. For anybody that, if you read the investigation reports on it and the things that they were asking her and the transcripts of the conversation, it's just creepy. Anyway, she eventually tells them to go away. She doesn't want to talk to him anymore. And she tells the jail, don't let them back in. As soon as they find out that they can't talk to her anymore, well, lo and behold, they set their sights on the Dassey boys. Set them up for a weekend at the Fox Hills Resort so that they can feel them out to try to figure out, if they know anything or whatever. And then they're bringing Brendan in on March 1st. The one Dassey boy who is 16 years old. He's got something of a limited mental abilities. They bring him in and proceed to feed him all the facts. Yeah, telling him like that they're like his father. you know, and not investigators, but I feel more like a dad, you know, to you. And the type of things that they do to screw with this poor 16-year-old kid's head, all right, is and when you see it, you'll know. Most people, 95% of the people that I've met, when they see it, they just go, they shake their head and just go, no, no, no. Nobody likes the look of this interrogation when you look at it. Problem is, it's hard to watch. There's a lot of people out there that struggle very much just to get through it because it's so difficult to watch these investigators and what they do to this poor kid. So, as I said, it was the end of February. They were harassing Jody, Stephen Avery's girlfriend, who Stephen Avery is Brendan Dassey's uncle. The whole reason they came after Brendan, folks, is because they needed to kind of lead pipe cinch the case against Avery because they knew it was weak, it had issues. And they, like, for instance, they had no trace of the victim anywhere in the two places that they were claiming that this happened. They had no trace of the victim. Not a trace. Not a nothing. Not a hair. Not anything. There's not even marks on the bedposts that she was supposedly handcuffed to while all this was happening. There's not even any scratches on the bedposts. So that's, I mean, as far as the fact that there was no evidence of a crime, they had a problem. They were like, the state was chasing this conviction. They were chasing it. No, there's no other way to look at it, because they knew it was weak. And for some reason, instead of revamping the investigation and maybe branching out into some wider areas and see if there was anything they missed, they went after Brendan Dassey and coerced him. Fed him everything that they needed him to say so that he could spit it back at them. There's points in the confession where he actually gets to the point because they're getting mad at him because he's not saying what they want him to say, and so they're asking him, why did you say this, or why did you say that? And he said, I was guessing. He tells them straight up, I'm guessing. I mean, he tells the investigators. That's a cry for help, saying, I don't know what hell's going on here. I don't know. But I mean, even after he tells them that he's guessing, they just plow forward. One of the other things is that you would think that if they were being dishonest, they would be leaving that all in the past at this point, right? They wouldn't be continuing their dishonesty now into the present day, would they? Well, a sensible person might think that's the case. Someone like me, or whatever. But no. Number one, you got Ken Kratz, who's out there spewing, I'm gonna be nice, spewing half-truths and kind of fantasies, really. Some things that he says, very few, are actually truthful and accurate. But most of what Ken Kratz says is meant to do a little mind game on you. Yeah, that's why he talks about vials of sweat. You know, officers would have had been carrying around vials of sweat. No. That's not how anybody would have planted DNA. That's not how that would happen. But by saying it's vials of sweat, this is the way that Ken Kratz's mind works. But by saying vials of sweat, he gets people to go, oh yeah, officers couldn't carry around vials of his sweat. Where would they get that? There's actually very little sweat. There's very little DNA in sweat. There can be some because of skin cells can like slough off, and they can be in the sweat. But generally, sweat itself has no DNA. So the mere suggestion of the sweat is ridiculous on its own. But by him suggesting that, he got people thinking, oh yeah, that is ridiculous. How would they carry? Well, because they wouldn't have done it with vials of sweat. They would have done it with swabs. Swabs containing DNA. That's how they would most likely do it. But that's another whole other issue. The point is that when it comes down to it, they didn't have the evidence against Brendan Dassey's uncle like they wanted it. And to make up for that, they went after Brendan Dassey and fed him the account, fed him the narrative so that he could spit it back. There's even one crucial piece of evidence that they are trying to get him to say it, because they're actually this the one thing that they hadn't said, the one thing that they hadn't fed him, right? And they held it back, and that was the fact that Teresa Halbach was shot in the head. They actually didn't tell him for most of the interview. Then when they started to press him for it, because they were trying to get him to say it, because if he had actually said, yes, she was shot in the head without them suggesting it, that would have been a corroborative fact, and you probably wouldn't see me talking about Brendan Dassey right now. But the fact of the matter is, he guessed 5 or 6 different things. We slit her throat, we cut her hair, we punched her, or actually he's saying Stephen did. Stephen punched her, this and that. But he's just guessing at what they want, and every time he guesses, the investigators say, oh, well, yeah, but it's something else. And so he had to keep guessing and guessing and guessing. And so when he gets to 5 or 6 guesses, eventually Mark Wiegert loses patience and just blurts it out. Okay, I'm going to come out and ask you, which one of you shot her in the head? Boom. That was it. Any chance of corroborating Brendan's story and making it actually viable, like you could actually put stock in it, any chance that they had went up in smoke when Mark Wiegert did that, because they'd already fed him every other fact. They had nothing else. And the fact that Brendan Dassey couldn't guess that, he was guessing 5 or 6 other things before he said shooting her. Well, he never did say shooting her, because Mark Wiegert said it. You know what I mean? So that goes to speak to how much Brendan Dassey had no clue. He wasn't there. He did not take part in any murder. And it's a darn shame that the Supreme Court didn't take up his case, because I don't know what they're going to do now. I mean, what's SCOTUS going to do now? There's a clear problem in our country right now, particularly with juveniles, but in particular with juveniles of limited mental capacity. There is a huge problem right now. Okay? These poor kids are getting, badgered into confessing and making confessions that are false, because that's what happens when you put the full read technique on just a juvenile. If you add the fact that juvenile is somewhat mentally limited, the read technique just makes them roll right over. The full read technique is not supposed to be used on juveniles. The Supreme Court has said this in multiple decisions. I just wonder how they're going to keep the state courts honest now that they've dropped this case and deemed it not important enough. The only thing that's going to keep these state courts honest is if they give away for these kids to be able to get habeas relief, to be able to overcome that high wall of AEDPA. And that would have been the way to do it. That would have been the way to keep the state courts honest. But from what I'm hearing from some people that are into the law, or that know it, better than I do, are saying that the Supreme Court would rather take a case straight from the state appellate courts or from the state district courts and make a decision on a case in that case, or in a case like that or something. I thought that was odd, because I mean, that's what they've done already. They've made decisions in that way before, and the state courts are just ignoring it. Why are they just ignoring it? They're just ignoring it because they know that on habeas review that they have this huge wall that nobody can get through called AEDPA, so they really don't have to worry about that. And it just allows them to go on with business as usual. And I don't see where they're going to change until somebody, the Supreme Court, somebody that can, even if it's the circuit courts, I don't know who it's got to be, but somebody needs to thump these state courts and go, look, hey, whoa, these kids need special care, especially the ones who are mentally limited. The Supreme Court dropped the ball, in my opinion, here. They let it slip. They really let one slip here, because in my mind, the only thing that's going to keep the state courts honest is putting habeas relief for these kids back on the books, making a way for these kind of mentally limited juveniles to have a case that they could point to as precedent that would allow them to overcome the high threshold of AEDPA that blocks them on their habeas reviews. So Brendan won his habeas twice. Two times he won. Judge Duffin granted his habeas relief, overturned his conviction, and threw the confession out. The state appealed it, so it goes over to the 7th Circuit Court. 3-judge panel here's the case. 2 are in favor of Brendan, so they uphold his habeas relief. 1 was in dissent. Then the gentleman we're going to talk about now, he's a real peach, Mr. Brad Schimmel. Mr. Brad Schimmel then goes out in the press and talking about, oh yeah, we're going to ask for an en-banc review. Yeah, this is, blah, 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 blah. Like, all sure that he's going to get this en-banc review after the state has just lost twice in a row. He's now talking about getting an en-banc review, which is even rarer. It's even rarer to get an en-banc review than it is to be able to get into the Supreme Court. That's how very little the en-banc review happens. Okay? It's even rarer than getting into SCOTUS. Okay? And somehow, after losing in the 3-judge panel, Brad Schimmel's in the press talking about, oh yeah, we're going en-banc review. This is gonna get overturned. Da 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 da. Whatever. All confident. And I'm wondering how he was so confident of that, because it was basically a Hail Mary to file for that en-banc review, and then suddenly it just all worked out so perfect for him. It's kind of strange to me. That's a little bit strange to me, especially when you consider the fact that the en-banc majority judges misrepresented the control question in the same exact way that the state and Tom Fassbender does. Yeah, these are federal judges in a circuit court. So it's interesting that Brad Schimmel was so confident that his Hail Mary was going to work. And then when we get the decision on that, that Hail Mary works and they get the en-banc review, and when we get that decision, suddenly the en-banc majority is misrepresenting the same fact that the state and Tom Fassbender is to this day. Hey, look, I'll let people draw their own conclusions, but why is the en-banc majority misrepresenting the control question in such a way? But hey, so let's talk about Mr. Brad Schimmel and what he said today. This guy, he's a piece of work. I mean, if you haven't seen the Brendan Dassey confession, okay, it's, like I said, difficult to watch. For a lot of people, it's impossible. People that really care about Brendan and stuff like that, and who are kind of sensitive, can't even watch it. It's difficult to watch. Because it's obvious what's happening to this kid while you watch it. It's obvious what you're seeing happen. And it's absolutely disgusting. And having all that in place, where we know that this poor kid was victimized for no other reason than the state was just really super zealous to get the conviction on his uncle. And so they coerced a 16-year-old kid with mental limitations to get the kind of lead pipe cinch and to provide the narrative in the media only, because they didn't use his confession at his uncle's trial. They didn't actually use Brendan's confession at his uncle's trial. They only used it in the media leading up to trial to affect the jury pool and, the hearts and minds of everybody in the area by feeding them this horribly, horribly diabolical story that the investigators fed to Brendan. So when you look at all these things, and it shows a clear intent by the state, it really, truly does. And Brendan Dassey needs help. He needs the courts to sit up and take notice that an injustice has occurred. And these and they've occurred before, and they're going to continue to occur until our court system pulls its head out of its rear end. Sorry, but when it comes down to it, that's what needs to happen at this point. Our court system has its head so far up its rear end that it doesn't see, it doesn't see the obvious when it comes to Brendan Dassey somehow. Doesn't see. I mean, and people, Brendan Dassey, he was mishandled in more places than I can count. His first lawyer, who was a relative of the victim, screwed him over. Because, well, basically, before he left as Brendan's lawyer, he signed off that they didn't need to have like an arraignment or a evidentiary kind of hearing to determine whether there was enough evidence to go to trial. I guess this guy just signed off and said yeah, and that's how they were able to just keep Brendan in custody the whole time. So there's that. His first lawyer kind of starts him off, on the wrong foot. Then the state appoints Len Kaczynski. Oh boy. That guy. If you haven't heard about Len Kaczynski, he basically took the case only because he knew his face would be on camera. He could get a lot of press from it because he was chasing a judgeship. And so he knew that this case would get a lot of attention. He was also, it seems very obvious, that he was working with the state. And he was not working for Brendan. He has been disgraced as Brendan Dassey's attorney. Every judge who hears about what he did says that his behavior is inexcusable, it's egregious and everything, but yet still it wasn't enough to get Brendan Dassey free. Because his own lawyer brought in an investigator to coerce his client, to coerce Brendan again, in the same way that the investigators did. Basically telling him what he wanted and making Brendan say it and write it down. Same thing. And then, after that, after he makes Brendan confess again, he then calls the investigators that originally coerced Brendan and sets up a meeting where Brendan goes and meets with them without his lawyer. His lawyer doesn't even bother to show up. So Brendan's alone again with the investigators that coerced him the first time. And they browbeat him and tell him and basically, blackmail him into calling his mother on the prison phone and saying that he did all this stuff. Because and they get him to do it by saying, because if you don't do it, we're going to tell her. We're going to tell her ourselves. So you want to be the one to do it, Brendan. You want to make sure she hears it from you. This is how they convinced him. This is the mind game that they played on him. And then guess what? That clip of him on the prison phone saying that got played in court. It's all fruit of the poisonous tree of Len Kaczynski. Okay, that's how poorly handled this kid is at almost every turn. He was not ever, until now, his current legal team is stellar. His current legal team has only his interests at heart and only his, only what's good for him. And they are stellar. That's Stephen Drizin, Laura Nyrider, and Robert Dvorak. And they are great. And like I said, they are also part of the Center for Wrongful Convictions of Youth up at Northwestern University. And they do a lot of good work. And like I've said, and I've said many times, Mr. Drizin is cultivating the next generation of wrongful conviction attorneys, and particularly for the youth. That's why this Center of Wrongful Convictions for Youth was created, because they have such a passion for leveling the playing field for juveniles in our criminal justice system. But even not just juveniles, but particularly, hopefully, the juveniles who are of limited mental ability. So they are doing great work there. They are, trying to be part of the solution instead of part of the problem, which is kind of what the state is doing. So, in light of all this, and what is obviously a coerced confession that they basically fed the kid because they wanted to hedge their bets with, his uncle, and make sure that they kind of wanted to get the lead pipe cinch on the conviction of his uncle, coerce him, and And then now, when the Supreme Court denied, dismissed Brendan and didn't give him his writ of certiorari, Brad Schimmel comes out in the press and says this. Wisconsin Department of Justice reacts. Wisconsin Attorney General Brad Schimmel, Shimmy Sham as I call him, reacted this way to the Supreme Court's refusal to hear the case. DOJ is pleased that the Supreme Court of the United States denied Mr. Dassey's petition for a writ of certiorari, and the decision of an en-banc panel of the United States Court of Appeals for the Seventh Circuit stands. We hope the family and friends of Ms. Halbach can find comfort in knowing this ordeal has finally come to a close. I don't know that you should be lying to people like that, Brad, because if you think people are letting this go, you're kidding yourself, dude. You're absolutely kidding yourself. You got to be sick as hell. I mean, if you think people are giving up on Brendan Dassey, you got another thing coming. So I'm gonna leave it on that note. Wisconsin, Brad Schimmel, Shimmy Sham, Walker, Fassbender, Wiegert, all of you, if you think that now the supporters of Brendan Dassey are going to go away, oh boy, you need to maybe lay off the alcohol or something. Because the people that care about Brendan Dassey are disappointed with the Supreme Court. Very disappointed. Actually, because they really missed an opportunity here. They really let something slip that could have really leveled the playing field for mentally limited juveniles in our system and made the state courts honest and give the special care that the Supreme Court has said numerous times is necessary, but not necessary enough to enforce it on habeas relief, I guess, is the message they're sending. It's been 25 years since the Supreme Court has made a decision on a habeas case like this. Yeah, it's just amazing that after 25 years and with all the momentum behind Brendan's case and the people behind Brendan, that SCOTUS didn't see the and let us not forget the six amicus briefs that were filed in favor of Brendan from the juvenile law center, from professors of law, actual professors who teach at universities and their whole life is the law. We had an amicus brief from there. Former prosecutors and law enforcement. The Innocence Networks. The Psychological and Psychiatrist Union or whatever, or council or administration filed. I mean, these very, very prestigious entities, 6 of them, and they filed all 6 at the cert stage. That's at the cert stage. Now, usually people don't file them at the cert stage. They wait and see if the Supreme Court actually takes the case first, and then people will write A briefs for the merits part of the process, the merit stage. To have 6 of them written at the cert stage, it just tells you how much of a burning issue this is at this moment in time. So I'm going to go ahead and leave it at that, folks. If you haven't already, please hit subscribe, and we'll see you.